Hi everybody, this is Jacqueline Vega with the Umansky Law Firm, and welcome back to Justice and Jury Trials with Jackie. The topic that we're going to be going over today kind of piggybacks off of the last one that we discussed in the last video that I made. Goes hand in hand with the burden of proof that the state has beyond a reasonable doubt. But today we're going to hone our focus a little more on the evidence that the state has to show at trial and what kind of evidence it is that they can use. For example, sometimes I have clients ask me, Jackie, the only evidence that the state has here are words, something that maybe an alleged victim said or that a witness said. Is that enough for the state to be able to prove their case beyond a reasonable doubt? Now, technically speaking, yes, testimony is evidence. That is technically enough for the state to be able to prove the charges against you. And I know that sounds crazy. However, what we want you to focus on is the fact that these witnesses or the alleged victim in the case has to come across as credible to the jury. The jury has to believe what they're saying, has to trust what they're saying. So, although technically testimony is evidence, and that is enough, there's still a little bit more there. They have to be credible. So, clients, potential clients who may be watching this, we don't want you to fear going to trial just because the state can technically prove their case with testimony, because there is more. That witness of theirs, that victim of theirs has to be credible. The jury has to trust them. And everybody, remember, if you're looking for justice, call Jackie. Si estás buscando justicia, llama a Jackie at the Umansky Law Firm.